one of the best ways to avoid going back to court is to have an awesome airtight parenting plan. And for our clients who are all dealing with high conflict divorce, custody battles, etc., often the reason they're back in court for months and years is because their parenting plan has what we call gray language, or language that's kind of vague. And so often the other side weaponizes it. So today's guest, I'm thrilled to say, is Connecticut attorney Kevin Hoffkins, who's going to talk with me about how to write a bulletproof or airtight parenting plan. So first, Kevin, before you even introduce yourself, where do most lawyers' parenting plans even come from?
Well, a lot of us have things that we have developed over the years of our practice, you know, um, basically through experience and through, sometimes we do converse with each other and get ideas from each other. Sometimes another attorney will send me a draft of what they want, and I'll look at it and review it. And, if something looks good, I'll include it, or they might do vice versa.
Yeah. Okay. So I'm imagining like lots of templates.
Yes,
Okay.
yes. I keep a pretty standard template on my computer, which I use for my clients, and basically just try to fill in the blanks based on their individual situation.
Okay. And now can you officially introduce yourself and say what it is that you do specifically?
Sure. Well, my name is Kevin Hoffkins, and I'm an attorney in Westport. I am an attorney and I am a litigator. I litigate divorces, and I've been practicing for about 35 years now. All of those 35 years have been involved in divorce in one way or another. I do some other things, but I would say my practice is 50% or more family law. And I've had a lot of high conflict divorces where parenting time is at issue, um, legal custody is at issue, parents who, are absolutely uh, can't even be in the same room together without yelling at each other. And I've had to deal with a lot of those kinds of cases. So I've got a lot of experience in this area.
Yeah. So I'm sure you've seen when those cases, like our audiences who are back to court all the time. And I know you had said that often with poor agreements, and hopefully you don't get any of your friends in trouble, but you said that lawyers are to blame. So what are some ways when we know that we've got like one of these difficult cases that lawyers can be more helpful? Is there something that our clients should be explaining to their attorneys or making sure their attorneys do, rather than just using a standard template that uses the word reasonable?
Well, if the attorney who is working with you, um, well, for instance, let's say you're doing a divorce and it's a custody matter and you're involved in the initial custody issues, the attorney should be working with you from the beginning and getting to know you, getting to know what the individual problems are that you have. And the attorney really should do a very good job of asking the relevant questions to get to know you and get to know what to expect. Because we've had experience with these different types before and we know what to look for. So your attorney really should be asking the questions. But I would say that, you want to make sure, the attorney is well aware of what what the other parent is like, what they're
Hmm.
capable of, what the problems you've had in the past. If you think the other parent is just irresponsible and would not, maybe be there at pickup for a child or something like that, then that's the kind of thing, you want to make sure that you tell them so that we know exactly what problems we need to present.
Okay, so not being there at pickup, that's always really common. So let's say we already know that this person isn't going to comply with the parenting agreement, that they're going to be really late. A lot of times they won't show up. They'll fight for custody, and then they'll just say, I'm not available that weekend. Like, is there any kind of language that can be put into a plan in terms of consequences? Like, what can we do to sort of make it clear that not if it happens, but when it happens, that there's a clear consequence?
Well, first of all, I like to put in a requirement that if you can't make it to a parenting time, then you have to give the other side notice, or they have to give you notice, and you should make sure that that notice is something that's reasonable. So, for instance, if you've got theater tickets for an evening when the other parent's supposed to have them for an overnight, or if you're planning on going away for a weekend, which might require losing the money you've put down for airfare or for hotels or something, you want to put something down that you're going to get that back if they don't give you the proper notice that's necessary. And you got to put in an amount of notice that's really reasonable based upon what you're going to do. So, I mean, nowadays I'm seeing hotels saying you have to give them 5 days notice. Otherwise, you're going to lose it,
Hmm.
lose your deposit. So, that kind of thing is something that you want to put in. You want to put in that there is a cost consequence. And usually you should have it related to what's the cost of you losing a night. Maybe it's daycare or babysitters. Okay, and
Yeah.
that's perfectly legitimate thing to put in.
Yeah. I mean, one of the problems we see is often it says someone has to give notice, but then there's no consequence for when they don't give notice. And then our client is left holding the bag going, I just had to cancel my vacation because the other parent's not showing up and there's nothing I can do about it.
Right. Well, so let's say you do put in a consequence that there's some money consequence involved. All right. The problem is if they just miss once, the amount of money that is at issue may not be enough to justify you going to court. Sometimes you have to let these things accumulate until there's enough that makes it worthwhile, or enough times that a person is missing that you want to go back for a motion for modification. This person's not making their, Thursday night overnight on a regular basis, then you want to go back and say, okay, let's cut the Thursday nights because he's just not using it.
Hmm.
And you want to try to find ways to document um, that the other parent did miss it. All right. So you want to make sure that it's documented. I would recommend using some of the third party apps like Our Family Wizard to document all communications concerning parenting times, um, at least emails and texts. Something that can be brought to court and used to say, yes, this person was missing on a regular basis.
Yeah. And so what you're saying is what we talk about all the time, like a one-off incident is not going to make that much of a difference, but it's the
Yeah.
pattern of someone's behavior. Plus, what you mentioned, we often refer to as the cost benefit analysis. So if you lost $700, but you're paying $500 an hour for an attorney to prepare and go to court, and then the time that it takes for the attorney to prepare and then the time in court, like that's going to cost way more than a few $100s. And so that's
Yes.
why it's unfair, but it's not worth it unless you
Right.
accumulate. And it's like, of course you don't want to accumulate, but you accumulate a number of incidents that you could say that now I'm going back for like thousands of dollars versus just a few hundred.
And just to address that, clients don't like to hear that they have to go back to court. They might want to hear that there's something they can put into an agreement that is going to just resolve this. But unfortunately, I think what I try to tell clients is that you really have to show the other side you're willing to go back to court and you're willing to do what you have to do to get this enforced. Because I think the most common times when the other side will manipulate you is when they think you're not going to do anything about it and they can just get away with it. And you really need to show, and I know it's costly with attorneys, some people represent themselves, but at the same time, I think you need to show the other side that you're willing to do it. And if you invest in that first time or second time, they may start to say, okay, I'm not going to get away with this, and they may start to be better. Some people, no, because they're that bad. They'll never be better no matter what you do. But I think with most people, if you show them that you're willing to go to court and enforce your rights, then they will start to change.
Yeah. And as you're saying that, I'm thinking about timing because one of the things we see happen a lot is right after an agreement is signed or there's a court order for a divorce, within the first month, the other side is playing games with the agreement where they're not paying the support or expense, just something where it's showing like they're still pushing and pushing. And so I think maybe just nipping things in the bud rather than saying, "Oh, I'll let this go, I'll let this go," then that's basically the same power dynamic in the relationship. Like, how much can I get away with? And you don't, so almost going back to court is a boundary. Like, I'm going to do it. I'm not going to tolerate this anymore.
That's right. Absolutely. Absolutely. But
Yeah,
again, you have to establish a track record first before you can go to court.
right, right. One of the things that you and I talked about a while ago was something you called the bottom line and how it relates to fear and anger. Do you remember what that was? I don't remember.
No, I'm not
I think that's
sure.
terrible. All right, then let's jump to the next thing.
The financial bottom line?
Maybe the financial bottom line.
Yeah. Okay. Yeah. I mean, I think cost is always a significant issue for clients. Obviously, it is, especially if your initial divorce cost a lot of money, and people are very apprehensive about having to go back to court.
Mhm.
But as we just said, I think that um, sometimes, in addition to showing a party that you're willing to go back to court, one of the things you want to do is you want to put into a parenting plan that if there is a violation, then the party who violated it has to pay the other party's attorney's fees. That's where the money can start to run up. And that's where you can have some significant bargaining power.
Absolutely. So I don't know if there's a name for that clause, but that clause, we love that clause. And someone told me at some point that it often says, like, when I know in my own agreement, it says something like, this is a court order, and anyone who doesn't comply with it or any orders resulting out of this initial order uh, may be required to pay reasonable attorney's fees, court costs, etc.
Hmm.
So we try to change the words a little. Instead of saying may be required, to say shall be required. And instead of saying reasonable attorney's fees, to say actual attorney's fees. Do you
Right.
think that makes a big
Well,
difference?
I do think you want to try to put shall in so it's not up to a court.
Right.
Um, because a lot of times courts may not award attorney's fees if they don't think that, judges vary. And sometimes judges won't do it if they don't think that the violation was very significant,
Hmm.
or that there was a lengthy practice of it. Um, but as far as, yeah, you can ask for exact attorney's fees. If it's in
Right.
the agreement and the court orders it, then it's the court order, and that's what has to be complied with later on down the road.
Right. And that worked, that I think I told you, Kevin, that I was pro se for years, and I was able to get attorney's fees back. Even when it said reasonable, I still got the attorney's fees back. So I'm very
Yeah.
pleased about that, and very happy that my divorce attorney put that clause in there.
Hmm.
So
Absolutely. Yeah.
yeah, so that's really helpful. Now, the other thing that we talked about was, I told you a story regarding the word designated in one of our clients' parenting plans, where a child was said that she could not be designated to a specific religion because one side had just converted and was trying to do things to make the child have that as their identity. What does the word designated mean, and why do you think that was a problem in this, in a situation like this?
Well, I think normally courts don't like to so it sounds like what you're saying is that after a divorce or after an agreement is put into place, that one parent tried to make that child one religion or the other.
Well, so
And
during the divorce, one parent converted to another religion and was a bit more extreme with that religion and said, I want our child to be this new religion. And so in their agreement, it says the child shall not be designated as any religion. But
right, well,
but then the
right.
ex was still trying to say, well, they're not this religion, but I'm still going to send them to this school and move to this country and do things that are associated with that religion.
Well, I think that most often, you can put into an agreement, if you can come to an agreement, that a child may be raised in one particular religion and not another. However, if you've got parents who disagree as to which religion that will be, then probably the most realistic resolution will be that the parents each gets to introduce that religion to the child during the time that they're with them,
Hmm.
and um, you know um, that is probably going to be probably the most realistic expectation I think that you can have. If you went and asked a judge for a ruling after a full trial, I think a judge might look at what is the history of the child. Has it been raised in one particular religion so far? Is there anything you can really point to that this new religion might be dangerous or harmful to the child?
Mm.
It's kind of hard to do with most religions, but basically, um, unless I think a judge could see a track record that a child had been raised in one particular religion and said, okay, we're not going to change that, then I think most likely a judge would order what I just talked about, which is that each parent gets to introduce their religion to the child while they've got the child. So, if the Sabbath for the particular religion is on a day when that new parent's religion is not having their Sabbath, then maybe it's not realistic they're going to get taken to services, but then they can also do other things. Um, so, yeah, I mean, I think courts like to give parents both rights to raising the children as much as possible.
Hmm.
Um, so, as far as negotiating goes, I think that's probably the best option that you could probably hope for in a negotiation. If somebody is really, really serious about the religion, will find it hard to agree to anything that really just excludes them from having to introduce their religion to their child.
Hmm.
They're going to be very passionate about it. You should expect that.
Yeah, yeah. So speaking of that, you had mentioned there was a story about a Jehovah's Witness that you had as
Yes,
a client. Can you
right.
tell that story?
Yeah, well, one parent was a Jehovah's Witness, the other wasn't, and they had a dispute. And essentially, that was the inevitable agreement that we came to was, that while the parents have the child, it was a little boy, they could introduce that religion to the child's life.
Yeah.
And usually, you might want to somebody might want to put in language you not allowed to disparage the other party's religion, in addition to not disparaging the other party.
Hmm. Yeah. And the
Yeah.
non-disparagement clause, like saying bad things or talking negatively about the other parent, that's like a standard in general in parenting plans, or at least it's assumed, right?
Try to, absolutely. Yeah. I definitely put those things into my regular parenting plans.
So speaking of that, that's always a huge issue in our community. And I think I told you one of the things that we're working on our current book is, well, the thing that we're working on our current book and an online course is what to do when your ex is trying to turn the kids against you in court and in life. And often in our clients' world, um, once the ex doesn't have the day-to-day way to still get at them, they'll be limited to always say three things: money, kids, and the court. So money and the courts go hand in hand, but the kids last the longest. And so they'll often start sending insidious negative messages about the other parent, even when there's a non-disparagement clause in the agreement. How often do you see that in your practice?
I can see people using money a lot, particularly paying for gifts, paying for things for the child to have that the child wants. I can say, yeah, I see that a lot. I don't see disparaging messaging too often because I think people are usually smarter than that. They know that that's something that can be used against them. Most likely, they would start to say things in a disparaging way in an oral manner. Okay. So yeah, I see that kind of thing happening as very often. If it does happen in a written manner, I mean, this is where I think you really want to monitor your children's communications with the other parent. You probably can't interfere with it, but you can monitor it in
Hmm.
the sense that you can look and see if there's disparaging things, if there's text messages or any kind of social media messaging or something like that. You want to look for it, and it's something that could be accessed and brought to court and shown that this person is disparaging the other parent. And that's something I think courts do take very seriously. They don't like to see it, and that's something a court would act on if you could show it. And you might be able to get an order that they can't communicate with the child through any of these other medias, you know and that actually may be a justification for asking for supervised visitation,
Hmm.
because that's pretty serious, and it's really, really hard to prevent that from happening on an oral manner if they're doing it in a written manner. So yeah, that would be a pretty good reason to go back and ask for supervised visitation alone.
Yeah, that's really good to know. And actually, just in the last week or so, or couple weeks, there was an article in the New York Law Journal published where somebody's really vicious OFW messages were used as evidence to get sole custody because one parent was saying such terrible things and making threats about the other parent, and the kid was involved in it, that parent lost just custody.
Yeah, absolutely. Absolutely. That's seriously damaging to a child in a lot of ways, not just the alienation aspect, but, it certainly hurts a child emotionally in a lot of ways.
Right, right. Yeah, I mean, because the child is half of each parent.
Yeah. As another matter though, I often talk to clients about trying to seek therapeutic ways of trying to overcome the alienation claims.
Mhm.
If you have a good therapist who can help you how to speak to a child, how to work with them, excuse me, that can really go a long way in helping to support the relationship and improve the relationship so that you can be able to keep your relationship with your child if the other side is doing things that are alienating.
Right. So when you said therapy at first I thought, "Oh no, the other side's not going to go to therapy." But you're talking about therapy for, let's say, the target parent that they can do to learn, because I know a lot of our clients are really frightened. They see it happening. They see
Yes.
the seeds being planted and they're just like, "Oh no, oh, no, no, this is just inevitable," but it's not necessarily inevitable at all.
Yeah. And I know from my own perspective, speaking as a parent, a therapist can help you to learn to speak empathetically to a child, how children listen, and help them to want to listen.
Mhm.
So if there's anything that has hurt your relationship with a child in the past, that they can help you to try to overcome these things. There may be some family therapy that might be necessary if you have something like that. But the therapeutic realm is definitely a very, very important way of improving those kinds of relationships.
Yeah, and that's so hopeful. I'm really glad that you said that because I
Yes.
think that'll assuage some fears. All right. I was going to say, back to like the language in these agreements. Are there ways that other ways you've seen language weaponized? I said often it's gray language where somebody will find a loophole and be like, "Well, it says reasonable and I don't think it's reasonable." But are there other mistakes you see made in parenting plans or agreements that you're just like, "Oh no, we have to we have to make this more specific, or we can't say this, we should say this instead."
Well, the first thing I would say is, first of all, I compliment you on talking about having a parenting plan. I have a lot of clients who, their manipulative spouse or the other parent says, don't have a plan. It'll be fine. If we do have a plan, just make it very general, like something we're going to be flexible with each other and we'll work it out. It'll be fine. You don't want to employ an attorney to help you with this because if you do, it'll be very, very expensive. And we
Right.
don't want to have to do that.
Right.
Okay.
Let's
These,
not use attorneys. Yeah.
no, that's just a recipe for disaster. I always tell clients, look, if you have a good relationship with the other parent right now and you think you can work it out, that's nice, but things can go sour. And you want to have a written agreement and a plan in place so that if things do go sour, you can say, okay, this is my time and that's yours.
Mhm.
That's what the plan was. You can always go back to it. But if you don't have a plan now, you're probably going to end up spending more money when you come back because redoing a parenting plan can be just as expensive as an initial divorce.
Mhm.
In a post judgment matter, can be just as expensive as an initial divorce. All right. So have a parenting plan, have something that is detailed as to pickup times. If we're talking about the week to week, day to day basis as to which time a parent has a child, have it very detailed as to what time pickups are and what time drop offs are. And you can do something like one parent will pick up the other child from school after on Friday afternoon and have them until Sunday morning or 5 o'clock on Sunday. Um, but pretty much there you have to do like we spoke about earlier. Make sure that the other parent is somebody who really will be reliable in picking up the child. Nothing more damaging to a child than when they're sitting around waiting to get picked up and nobody's there to pick them up.
Yeah.
Okay, even if
Yeah.
the child is safe physically, emotionally, it's very damaging. Um, as far as other things go, I think you want to get holiday schedules specifically done. Um, I had a case once where their holiday schedule said April vacation with the father. All right. Mom came along and said, sorry, April vacation is only Monday through Friday. So when April vacation came up, dad said, well, I want to fly out on Saturday and come back the following Saturday. Mom said, no, it's only during the week. Do you really want to specify what days those things begin, even what time those things begin? and make sure that it's put in there, and expect to have to deal with it when you make your travel plans. Um, so, make sure the holidays that are important to you are spelled out in there. For some people, a typical one that I see is some families Christmas Day is the big day, and for some families Christmas Eve is the big day is the
Mhm.
big part of the holiday. If that's a division, then maybe one party can have the child on Christmas Day and the other party can have it on Christmas Eve, and everybody's happy. But make sure that Christmas is really spelled out, or any other holiday. If it's a 3-day weekend, for instance, Thanksgiving, they usually get the Friday off. So if Thanksgiving is with one parent, is that just Thanksgiving Day, or does that include the whole weekend? So those kinds of things really, really want to be spelled out. I go through every school holiday that that school district has. I go through religious holidays too. Okay, sometimes one parent may be more religious than the other and want to have the children on the religious holiday, like maybe Easter. Maybe Easter or Yom Kippur is important to one parent and not to the other parent. So you got to spell out where and what times those days of those holidays the children are going to be with that parent. So
Yeah.
those are very, very important things, and I would say just make sure that you've got specific dates and times as to when those are going to happen. Father's Day, Mother's Day, make sure it's spelled out. Child's going to be with the father on Father's Day, with the mother on Mother's Day. Make sure it's spelled out. Children's birthdays. Um, who's the child going to be with? Um, I've seen parents fighting over who's going to have a birthday party for the child,
Mm-hmm.
and
That comes up a lot with our clients too. Do I
it's
have
like,
to invite the other parent? That came up
yeah,
yesterday. Am I going
yeah,
to
and
get
they
in
end up
trouble if I
having,
don't invite them?
well, the child does well because he has 2 birthday parties, maybe.
Right.
Maybe that's okay. Um, but you want to make sure that that kind of thing is spelled out, and make sure access. I mean, if both parents are still legal parents and have joint custody, they will both have access to medical records and access to school records. Okay. Um, but if there's a sole legal custody for one parent, then you might want to see, even the parent doesn't have legal custody might want to be involved and still might want to have access to medical records or um, to school records, just to know how this child is doing, be able to call the parents or be able to call the teacher or go to parents' night. We're in that time of year right now. So,
Oh, yeah.
those are the kinds of things you really want to spell out.
Yeah. And as you're talking about holidays, one of the things we talk about when putting together parenting plans with our clients or ideas for parenting plans are also traditions that your family might have. That if you go to court, no judge is going to remember that on every 4th of July, you and your grandmother get together with your family, and that needs to be written in. So, so speaking of that, what are the benefits to doing an agreement versus a court order, like doing it outside of court and possibly writing it yourself versus having a judge order it?
I would always recommend trying to come to an agreement if you can,
Mm-hmm.
because judges have a terrible record of not being very specific on these things. So they may say, after, every other weekend with dad, but they don't spell out when the weekend begins.
Mm-hmm.
Very often they'll say, child support will be in the amount of X dollars a week, but they don't tell you what's the first day that it's due. And that's often a dispute. So they have a bad track record of putting in details. So I would definitely recommend doing your own if possible. Okay. And try as hard as you can to get one. Also use a mediator. If your attorney and the other attorney are still fighting, because attorneys, we're hired to advocate for our clients. So sometimes you can use a mediator. Sometimes you can use a family therapist to help you come to some kind of agreement on these things.
When you
And
talk about mediator, do you think, like, as an attorney, we see a lot of mediations where it's an attorney and a client and the mediator, but a lot of the mediators we've interviewed say that they think that it works better for clients when there's no attorneys present. No offense, Kevin, but they said that lawyers are advocates for their clients, and sometimes a great mediator can kind of guide them to come to something without the extra person in the room advocating.
personally, I try very hard to let my client do their own work in the mediation. I get concerned that they might get run over
Mm-hmm.
if they're in a mediation. Even if they're in a mediation, if I'm not there, some clients just are not aggressive and assertive for themselves,
Hmm.
and they really need to be. So, and they need somebody there to do it for them. So I try not to interfere, but I try to say, you told me you have this problem before. Don't you really want to try to make sure this doesn't happen again? Um, so I understand what the therapists say because I've seen plenty of attorneys who are too over the top. They basically take all the problems that you had negotiating in court and bring them right into the mediation room with a therapist. And it's no better because that other attorney is just being way, way too aggressive.
Hmm.
Okay. Um, so, you kind of have to feel it out on an individual basis what this individual client will be able to do. Would they get run over? Will they be assertive for themselves? So you really just kind of have to feel it out. And sometimes you just have to take a bit of a risk uh, because some clients, even if you feel that they're assertive, they may back down on some other things. And, it's always good to keep in touch and tell them, don't make any final agreements until you come back and talk to me.
Yeah.
And I will at least review it with you and we'll go over it and we'll see what we can add here that will be helpful for you.
So speaking of that, one of the pieces of advice that I got from my divorce attorney that we use with all of our clients is you should be the one, or your attorney should be the one drawing up the initial agreement or parenting plan. You don't want the other side to do it. You want to do it. When it happened with me, I was like, well, I don't want to pay you. Why am I going to pay you, attorney, to do all this for me when it's not fair? And he said, believe me, you want me to do it because his attorney is going to mess it up, which proved to be the case. I'm thrilled that my attorney wrote it. What are your thoughts on you being the one to draw up the agreement or the order or the parenting plan?
Having something that you believe in to be a starting point for negotiations can be really helpful. So I think it's probably a very good idea to be the person who starts out with a proposed agreement. I have seen some attorneys who, again, there are some attorneys in the divorce field that are just way over the top in aggressiveness. They're trying to show their client that they're big, bad attorneys. But, and in fact, what they all end up doing is making the process so much worse.
Mm-hmm.
A lot of times, if we come to some kind of an oral agreement, whether in family services or just talking among ourselves, another attorney will say, okay, I'll write it up and I'll get it to you. And then when I get it, there's like 20 things in there we never agreed to. you know?
Exactly. Exactly. Right?
So, and then you got to go back and they'll say, oh, this is standard. You have to do this. And then we're kind of like back to square one
Mm-hmm.
on some of these things. So, yeah,
Yeah.
I would definitely propose try to put it together yourself if you can.
Yeah.
The
Yeah.
first draft.
All right. So speaking of aggressive opposing counsel, I know you and I also talked about something that we share in terms of value, and that's child-centered divorce. Can you talk about just briefly, what is child-centered divorce and how that matters when it comes to drafting an agreement or a parenting plan?
Well, I think that what it means is that you're really putting the interest of the children first. I think that, I always try to make sure that both parents have good access to the children and a fair parenting plan based upon their individual situation. Not every parent can have a 50-50 split with the other parent. Okay. But if they can, then, they should. And we're seeing in this time period, we're seeing a lot more fathers who want to have a 50-50 split. Okay. Um, to some extent, they're doing it because we're culturally changing and dads really do want to be more involved. To some extent, those fathers are looking for a reduction in their child support
Yeah.
because if they've got a 50-50 split, they can pay less or maybe pay nothing. Um, but child-centered divorce, I think, really means taking into consideration the child's individual issues. You can have a child who has, perfectly healthy in a lot of ways, but maybe some emotional issues really have to be dealt with. You can have some children with special needs that really need to be dealt with. And you really want to make sure that those things are taken into consideration. Most importantly, though, I just talked about trying to give both parents equal access. Obviously, the exception is if the other parent is somehow dangerous or not good for the child. Then you have to go and fight for a limited access of that parent to the child. And
Yeah.
sometimes it could be supervised visitation. Sometimes it could be, maybe no overnights, just a few hours on a Saturday or a Sunday or something, or during the week. but at least dad still gets to see him. But there's limited chance for dad to do something bad, or mom. So those are the kinds of things that you just has to be your first priority when it comes to the parenting plan. And I like to do the parenting plan first. When I'm talking to my clients, I try to get the parenting issues done first before we really start to talk about the financial issues.
Mm-hmm.
If we're doing a divorce, you kind of have to start doing some discovery about financial issues because the judges aren't going to give you a lot of time on this. But you really want to get the parenting stuff done first and get that going so that is resolved. And then once that's resolved, really a lot of the financial issues kind of fall into place.
Yeah, that's really good to know. And you think like one of the values of the court that we've seen are the child's stability, consistency, and routine. And I would think that the earlier you can establish or keep a routine, this way, the parents can be doing whatever, but the kids still know what's coming up and things are more predictable because you don't want to just, we always say like the goal is to get the kids through it as healthy and unscathed as possible. So
Yes,
for them to at least know their schedule and what to expect, it should make things as easy as it can be.
yeah, and try to keep them in the same school system if possible. Okay. Try to make it so that they're going to have the same activities. If they like a certain after school sport or something or a certain club, they're going to continue to be able to do that in spite of whoever has the children. So, if the after school club is meeting on Thursdays, and that's when one parent has like a Thursday overnight, you want to make sure that is taken into consideration first. That parent who has that Thursday overnight has to say, okay, they have to change their schedule and work it around so that the child still goes to that thing, and you don't say, okay, it's my overnight, I get to do whatever I want.
Right. So it becomes more the child's time is the most important consideration, not just it's my time or the other parent's time. It's the child's
Yes, and
time.
that can be written right into the parenting plan. It should be.
Yeah, that's great. Well, thank you so much, Kevin. Before we go, can you tell people how to find you?
Okay, well, my office is in Westport. My office
Connecticut.
is at 8 Wright Street. Oh, I'm sorry. I know your other places. I only practice in Connecticut, though. So,
Okay.
but it's at 8 Wright Street. That's WRIGHT. And my phone number is 203-612-7015.
Okay. What about your website?
My website is hoffkinslaw.com, HOFFKINSLAW.com.
Okay, great. Well, thank you so much. This has been really, really helpful.
Oh, I hope I have. I hope I have been.
Definitely.
Yes.
All right. I'll talk to you soon.
All right. Thank you. Bye-bye.
Bye.